Good morning, Europe. Good afternoon, Southeast Asia. Welcome to our webinar today with the topic about protecting intellectual property in retail sector in Southeast Asia. The webinar is brought to you by the Southeast Asia IPR SME Helpdesk, an initiative of the European Commission. My name is Jane, Project Assistant. I will be the moderator of today's webinar. Joining me is Ms. Nora Bihari, Project Manager of the Southeast Asia IPR SME Helpdesk, who will be introducing about our service, and Mr. Trương Mạnh Hùng, the Director Managing Partner of BMVN International, a licensed law firm and IP agent, as well as a member of Baker McKenzie. He also our external expert of our helpdesk. But before we get into the presentation, let's make sure that we all have a good understanding of how the webinar platform works. So, throughout our presentation, we are looking forward to a lively discussion. So please get in touch by typing in your question and comments using the question box where noted. Send at the IP expert a question here. When you are writing your questions, please keep in mind that we will hold on to those until the end of the presentation and we'll answer them during the Q&A section. Also, please keep in mind that we are recording today's webinar and it will be available for download from the webinar section on our website in the following days. So now let's have a look at the agenda. To begin with, Nora will provide a short introduction about our helpdesk and its service. After that, Mr. Hùng, our expert, will present 3 key points about IP protection in retail sector in Southeast Asia, including an overview of Asian economic community, the trademark prosecutions, and the trademark enforcement in ASEAN. And last but not least, we will have a Q&A section where we can raise any question or concern related to this topic. Our speakers are happy to address all of them. Now, please welcome Ms. Nora Bihari, our project manager. Nora?
Welcome to everyone who is attending our webinar today from Europe or also from Southeast Asia. I would like to give you a very brief introduction to the Southeast Asia IPR SME Helpdesk project, which is an initiative of the European Commission. Our goal is to support small and medium-sized enterprises to protect their intellectual property rights in or related to Southeast Asia. How can we support you? We offer a wide range of services. One of these is the inquiry helpline, so you can get in touch with us via email, phone, or in-person consultation if you happen to be in Vietnam, or schedule a Skype call with us and we will reply your IP questions, help you to identify your IP asset that you want to protect, or help you to prepare an IP strategy. We try to be quick, so we reply within 3 working days in order to make sure that you quickly get information from us. We also have publications available on our website, fact sheets and guides about various IP topics. We have general topics, for example, trademark, copyright. You can download all these publications free of charge from the website. And some of our publications are more customized to a specific industry field, for example, ICT, medical devices. We also have fact sheets on each Southeast Asian country, so you can get an overview about the about the IP landscape of the various Southeast Asian countries. Besides that, we also offer trainings, either on-site or online trainings. We do on-site trainings both in Europe and in Southeast Asia. So if you follow us on social media or you check our event calendar on the website, you will be updated about all our trainings that are happening across Europe and Southeast Asia. And as today, we also do webinars, usually 1 or maximum 2 webinars a month. So also you can be updated and join our webinars if the topic is interesting for you. And then we also have some interactive e-learning tools, for example, e-learning modules that you can also check on our website. It's an interactive tool to help you to learn about IP. You have a quiz session at the end of the module, so you can test how much you understood from the module. So I think now you are well aware of our services, and I would like to give the floor to Mr. Hùng to discuss this interesting topic today. And at the end of the webinar, we can discuss more about the services or any other question you may have. Thank you for your attention, and Mr. Hung, the floor is yours.
Thank you so much. Good morning, Europe. Can you hear me? Can I hear some yes or no from your side?
Yeah.
Europe?
Mr. Hung, the audience is muted in order to avoid any background noise, but yes, we can hear you. All good.
Okay. Thank you so much. Oh, Nora, thank you so much for your introduction. My name is Hung, and I'm the country managing partner Baker McKenzie in Vietnam. And I head up the IP practice in Vietnam for many years. I started with Baker McKenzie in 1997. Before that, I worked for a French law firm and a Vietnamese law firm. Baker McKenzie, we have an office in London as well. So I come back and forth to London from time to time for client business. So today, we will have 1 hour working through the main topics about IP trademark protection in ASEAN. My presentation includes actually 3 parts. The first part, we will talk about a little bit about AEC, ASEAN Economic Community. And the second part, I will touch upon the trademark prosecution in ASEAN. Okay, now let me start with the first part of my presentation. So people talk about ASEAN, AEC, and people have quite a misperception about what AEC means. So AEC actually is not a replica of the European Union. We don't have the common IP office in ASEAN. We don't have central government, and of course we don't have the common currency. But ASEAN actually, what makes ASEAN important is it works under the 4 pillars. Number 1 is the competitive policies. Number 2 is consumer protection, and number 3 is IP rights, and number 4 is infrastructure development. And of course, now we are talking about taxation and e-commerce as well. So ASEAN, here the AEC, actually we have different jurisdiction with different pace of development. So while Singapore has advanced legislation and enforcement of infrastructure, like Brunei, Vietnam, Laos, Cambodia, Myanmar are very young countries, and then it's still underdeveloped in terms of IP enforcement and protection. Laos, Cambodia are relatively new in terms of IP regime and basic legal infrastructure in terms of IP protection and enforcement. Myanmar is a new it's a new system they just adopted, the new trademark, industrial design, and patent law. And the current system will be replaced by a first to file principles once a new law will become effective. Changket, I cannot change the slide from my end. Can we help with that? Why don't we just proceed and then we can send the slide later on. How about that? So ASEAN countries, we enter into different treaties like ASEAN and China, ASEAN and Japan, ASEAN and Korea, India, and Australia and New Zealand. And those create an international framework for trademark, for IP, and also the trade practice in ASEAN countries. And right now, I will go to the trademark prosecution in the ASEAN. So we talk about 9 countries where Indonesia, Malaysia, Philippines, Singapore, Thailand, Vietnam, Myanmar, Laos, Cambodia, and Brunei. So let's talk about first one, the copyright. So in those 9 countries, we have the system to protect copyright and related rights. For patent invention, we have all the mechanism to protect patent in those 9 countries, except in Myanmar, where pharmaceutical patent is not patentable right now. And maybe once the patent law is adopted, and then the patent law, we can do that in future. For trademark, actually we have mechanism to register the trademark in 9 countries, and except for the trade name in the Philippines, it can only be protected if it is registered as a trademark. And right now, I will talk a bit about the trademark prosecution legal framework in ASEAN. In Indonesia, we have law number 20 adopted in 2016 on trademark. Malaysia, we have Trademark Act adopted in 1976. It's quite an old law, but the law has been amended in 1994, 2000, and 2002. In the Philippines, we have the IP Code, which has been amended from time to time, and also another law called Use of Duty Stamped and Marked Containers. Singapore has the Trademark Act adopted and revised in 2005. In Thailand, we also have a Trademark Act adopted and amended recently. Vietnam, we have the IP law adopted in 2005, but given that Vietnam now joined the CPTPP and EVFTA, and the National Assembly plans to amend the IP law sometime very soon in Vietnam. Myanmar, as I just mentioned, they just adopted the new trademark and industrial design law, and it's still under consideration for implementation. Laos, Cambodia, they have an IP law as well, and Brunei, they have a Trademark Act adopted in 2000. So now let's talk about the trademark prosecution overview in ASEAN. So ASEAN is a quite interesting jurisdiction where we have, first to file country and first to use country principles. So most of the trademark rights are established on the basic registration, except for the well-known trademark. Why except for the well-known trademark? Because well-known trademark do not need to be registrable, but again, it can be protected if the trademark are considered well-known. Scope of protection. As you can see, trademark is territorial effective. It means, if you file a trademark in one country in ASEAN, it's only effective in that country. So right now, we don't have a mechanism to prosecute trademark in all ASEAN countries. And of course, we have Madrid Protocol and Madrid Agreement, and I can mention later on. Term of trademark protection in ASEAN, mostly 10 years and can be renewable many times. It's very importantly to remember trademark rights can be assigned or licensed. Assignment means you can sell a trademark to a third party, and of course, in order to effect the assignment, and then you need to record the trademark assignment with the trademark office. Licensing means, trademark licensing means you can allow somebody to use the trademark and of course collect royalties. Most of the countries in ASEAN have a law requiring trademark owners to use a registered trademark. If you don't use a mark, like within 3 consecutive years or 5 consecutive years, and then the trademark can be cancelled. And right now, I will talk about the difference between first to file principle and first to use principle. So what means first to file and first to use? So ASEAN, we have countries who use a common law system like Malaysia and Singapore, and we also have countries like Vietnam and the Philippines and other who are considered like the civil law system. So first to file means the trademark with the earlier filing date will be granted registration. It means if you file early, and then you can enjoy protection. And it means that if you are late in filing a trademark in a few countries in ASEAN, you may lose the right to protect a trademark. So first to file means first come first served as soon as possible. First to use means the trademark used earlier in commerce will be granted registration. It means you need to provide evidence of use and intention to use, and that will be submitted when filing an application in order to prove that you have the earlier in commerce used. So there are specific limitations and conditions regarding first to use right, variable in each country. Right. So now let's verify which country apply first to use and what country use the first to file principles. Next slide. So Brunei is the first to file. Cambodia likewise, first to file. Indonesia and Laos, first to file. And the Philippines, Singapore, Thailand, and Vietnam actually is the first to file. Yeah. So first to use now in Malaysia. So it means that you have to prove you use the marks in commerce before others in order to be able to get protection. So now let's talk about some national best practice here. In terms of this disclaimer practice. So in Indonesia, there is no practice of disclaimer, but Malaysia, the Philippines, Thailand, Vietnam, Laos, Cambodia, and Brunei, it has disclaimer practice. It means when you have a registration, trademark office can disclaim what can be protected and what cannot be protected. And sometimes, in order to be protectable, the IP lawyers normally advise you to add a house mark to overcome trademark objection. For example, you have a trademark like Unilever is a hallmark of many trademarks like Dove and Clear, and sometimes Clear may seem to be a bit not registrable, and people can ask you to add the house mark Unilever. So Vietnam in the past accepted to add the house mark, but right now the practice seems to be not very relevant now. So in Indonesia, no practice to add the house mark. Malaysia, they accepted. Likewise, the Philippines, Thailand, Vietnam, limited cases, but other countries, they don't accept to add the house mark in order to overcome a rejection. So what about the foreign language mark? Whether they are accepted for filing and protection in ASEAN countries? Indonesia, they accept. Malaysia, the Philippines, Singapore, Thailand, Myanmar, Laos, Cambodia, Brunei. So most of the ASEAN countries here accept foreign language mark for filing and protection. So Vietnam is a bit different. We don't accept anything but Latin-based word. So if you file a trademark in Japanese or Chinese, of course, the trademark office will ask you to transliterate it into Latin-based language as well. So what about filing a trademark in black and white and color? So in Indonesia, Vietnam, Cambodia, and Brunei, if you file a trademark in black and white, it doesn't mean that you will get protection in different colors. But in Malaysia, the Philippines, Singapore, Thailand, and Laos, of course, they will accept the color protection even if you found in black and white. Okay. So now let me move to another slide. We talk about. I will talk about the Madrid Protocol, the trademark prosecution in ASEAN. So can you move to the slide with trademark prosecution in ASEAN, International Trademark Registration Madrid Protocol. So even though in ASEAN we don't have a common IP office like European Union, we dream to have about it, but now because of the different countries have different perspectives in terms of IP protection, so that's why we haven't achieved any principles about that. But again, with the Madrid Agreement and Madrid Protocol, brand owners, applicants from European country can still file international trademark registration in ASEAN. So right now, an international treaty, Madrid Protocol, it has been administered by International Bureau of the World IPO, we call WIPO. So this Madrid Protocol provides a method of achieving expanded international protection for a trademark that has already been applied for or registered in African countries. So how it works? International application does not result in a single international trademark, but instead in a bundle of national or regional trademark rights. This bundle of rights is based on the acceptance of request for extension protection by each designated contracting party. So let's talk about some advantage about using this international trademark registration. First of all, it's a centralized filing procedures. It means that European trademark brand owners, they can file one application in one language, pay one fee, and any recordal of changes on registration will take effect for several designated countries at the same time. So it means that, if you are a member of Madrid Protocol, then it can use an application-based or registration-based in order to designate to the countries in ASEAN, of course, to any country where, who they are the member of Madrid Protocol. However, we found out some issues, we call disadvantages for filing, international application. Number one is dependency and central attack doctrine. It means for the first 5 years from the date of the international registration, anything which affect the basic application means application you use in order to designate the ASEAN countries, and that it will the same effect on international registration, and in turn, trademark protection in the designated country will be impacted. So that's why central attack doctrine can be an issue when you use international trademark registration here. Now, let's talk about some procedure in doing international trademark registration covering ASEAN countries. Next slide. So an applicant can use a basic application or basic registration from the office of origin, the office where you are based, and then from there you send application to your IP office using the form provided by WIPO. And WIPO, of course, will within few months they will deliver the letter to the office of designated contracting party, maybe like Singapore, Vietnam, or Laos, Cambodia, depending on which country you designate for the trademark to be prosecuted. So interestingly, if the scope of protection of the international registration will be determined by substantive examination under domestic law, it means after the local office receives the application from WIPO, they will consider examination at local office. However, within 12 or 18 months, if they don't give any feedback about examination, and then the trademark will be automatically protected. And WIPO will, note it on the website. Right now, I can note that most of the member countries in ASEAN have acceded to the Madrid Protocol, except for Malaysia and Myanmar. And we hope that Malaysia and Myanmar will become a member of Madrid Protocol very soon. So trademark filing trend and development. And right now, having talked to my colleague in ASEAN countries, I put down here a number of bullet points for you to consider about the trend and development of the trademark protection in ASEAN. Number one, protection of mark filed in block letters and black and white is not uniform across ASEAN countries. It means that, the principles about black and white registration of block letters is not consistently applied in ASEAN countries. So charges for each item of goods may be imposed by some ASEAN countries, still inconsistent from different countries. And the next one, the protection of 3D mark and color only mark is not uniform as well. You need to be mindful about first to file country in order to ensure that your trademark rights will be prioritized and protected before you come and do business in ASEAN countries. So trademark filing in Myanmar will be allowed shortly, and make sure that Myanmar is a new country with the new law, new IP law. So make sure that the trademark, your IP rights will be protected in Myanmar. Malaysia new trademark bill adopted in 2019, recently in July, and expected to be effective very soon. And the bill reflects Malaysia's accession to Madrid Protocol and introduce certain new trademark prosecution regulation and protection of non-traditional mark like sound mark and SIN mark. Okay, now let's move to the trademark enforcement in ASEAN countries. I will continue, and we will have a Q&A section end of my presentation, so don't worry about it. So when you have a trademark right in ASEAN countries, the next steps is how to enforce them in ASEAN. And the big question is, how to make sure that your trademark rights are properly protected and avoid trademark infringement in ASEAN countries. So if I can summarize here, I can tell that types of trademark infringement and violation in ASEAN include, 4 actions. Number 1 is the unauthorized use of the mark in the course of trade. It means that somebody just use a mark without your authorization, and so it can be amounted to the concept of an unauthorized use of the trademark. Secondly, the counterfeiting. Counterfeiting trademark means somebody use a mark, identically in the goods and services that you trade or you produce. For example, if somebody use like Hugo Boss in fashion brand in ASEAN with your and produce it without authorization from trademark brand owners, or try to counterfeit it and import trademark counterfeiting. Passing off, and the next one, and the last one is unfair competition. So passing off is a concept where it's not quite existing in Vietnam, but for Vietnam, it's quite considered like unfair competition. So what you can do in order to enforce your trademark rights. So I summarize here 5 actions where you can do. Number 1, you really need to have a watch system. For big brand owners, they have very, quite a big core IP team where they can watch out, from the website, from the trading channels, and of course, the watch system is really important. Sometimes they use outside counsel to watch whether third party will file or successfully file a trademark in ASEAN countries. But of course, you don't have that service, and then sometimes you get a cold calling from IP lawyers or IP agents from ASEAN and say, hello, we found out that somebody, Mr. A, Mr. B in Singapore or Vietnam, is trying to file a trademark called Hugo Boss, something like that, and you can take action. The next one is, sending out a cease and desist letter. It means, the first action you can do with very minimum cost is to send a cease and desist letter to the infringer, telling them to stop trademark infringement and sign undertaking not to do trademark counterfeiting, not to commit in trademark infringement anymore. And the next option you can do is the self-protection. Of course, for copyright, you can come up with some idea, some technological solution where you can protect your copyright or trademark. Enforcement measures, of course, we can talk a little bit later on about civil action, criminal action, administrative action later on. And of course, authorities, they can conduct an ex officio action, or we call it conducted by competent authorities. Okay, now let me talk about what system and some example service, some what services here. So very often, we have bi-weekly online search. You can have, access result of the online search. This one actually, you may engage an outside counsel to watch for you to find out, as I mentioned, whether you can detect any third party trying to file or successfully file to trademark in ASEAN countries. And this kind of bi-weekly online search can tell you not only the trademark issue, but also a trademark counterfeiting issue, online issue as well. Okay, and now move to the enforcement measures. Very important, we have 4 core action here. Action number 1 is civil action, or otherwise we call litigation. Action can be filed in court in ASEAN countries, like Vietnam as well, and other countries like Malaysia, Singapore, the Philippines. Usually, when IP owner seek compensation for infringement committed by a third party. It means when you try to demand for compensation from the infringers, and of course civil action is necessary to do so in order to achieve the objectives. Civil actions are generally more costly and quite intensive. Like Vietnam right now, we don't have an IP court, but that's why a lot of judges in Vietnam IP system, we don't have good judge to understand the IP laws. But in Thailand, in Malaysia, in Singapore, they all have IP courts where they can deal with IP cases quite properly. Like Thailand in 1997, after the financial crisis, the bubble economy, and then they introduced quite interesting IP system where they can attract a lot of foreign investors to do business in Thailand, and one of them is that they establish an IP court, and they can tell the whole world, in Thailand, we can ensure that IP protection is really good, sufficient for foreign investors. The next action to take is administrative action. This one is quite common in Vietnam and other countries as well. Normally, administrative bodies, they can initiate an ex officio action where they have their channel to detect the trademark of the patent or trademark infringement, and from there they can take action. And of course, sometimes they can call upon the trademark owners to come and verify whether products they seize are counterfeit or not. And of course, this action is quite cost-effective and quite fast as well, because they can take action very quickly with minimum cost. Criminal action is quite rare. Like in Vietnam, they only take action when the cases are so serious. Normally, they don't take very routine cases to do criminal action. So usually applied when there is a very strong evidence of infringement, or as the last resort again, recurrent infringers, or when the infringement acts do harm to the public. Like for Vietnam, Malaysia, anything that's related to pharmaceutical cosmetics, would be harmful to, the human being, and then they will take action. And of course, it can be effective during negotiation or making infringer to comply with demand. And of course, criminal action has a lot of effect, carry a lot of weight, and of course, it has a threatening effect, for infringers. Last but not least is the border measures. Most of ASEAN countries have a custom recordal procedures where brand owner can record the trademark with the custom procedures in order for them to detect whether there is any incoming or outgoing counterfeiting, from the countries. And of course, have to pay a little bit fee if you brand owners agree to take an action when they get notification from custom officials. Okay, now we talk about enforcement measures. Civil action against infringement. Yes, in most of the countries, and civil action against passing up an unfair competition. The answer is yes in most of the countries except for Laos. We don't know why Laos doesn't accept to do this. Maybe the law is not sophisticated enough to do that. That's what I guess. Criminal action noted. It should be noted that for Indonesia, criminal action can be taken for own IP rights. That's very interesting. But in Malaysia, only copyright and trademark can be subject to criminal action. The Philippines, likewise, like Indonesia, for own IP rights, can be prosecuted under criminal law. Singapore, only copyright and trademark. Thailand, only trademark, copyright, patent infringement only. Vietnam, we only accept 2 cases, trademark and copyright. We can be prosecuted under criminal law, not patent, not designs. Myanmar, copyright and use of failed trademark. Laos for own IP right. In Cambodia, it's quite difficult because of the lack of experience by IP officers. And Brunei for own IP rights. So border control and customs recordal. So most of the country except the border control. In Thailand, they monitor IP infringement at the border gate, and like Vietnam as well, it's quite effective. Okay, Now, let me give you some overview on trademark enforcement and trend and development in ASEAN countries. Next slide. Excuse me. Next slide. So, having practiced law in Vietnam and working closely with all of my ASEAN colleagues, I could do a short summary here about some trend and development. So we can see that administrative measures are not available in every ASEAN countries. So Vietnam, they're effective, but in like Singapore, we don't see it's quite active. All of ASEAN countries provide for civil judicial procedures against trademark infringement. However, they are not equally effective. Like Vietnam, as I mentioned, we don't have an IP court in Vietnam, and the judges in Vietnam are not very knowledgeable in terms of IP laws. So that's why when we deal with IP cases, it's quite difficult. However, the trend is we try to move a lot of IP cases from traditional administrative channels to civil court cases. Criminal penalties may be ineffective in ASEAN countries, some ASEAN countries, due to the ambiguous regulation and the lack of the experience in dealing with trademark cases. But I have to say that criminal penalties are really effective for setting for making sure that the infringer will not repeat the infringement again. Traditional enforcement measures are changing every day in order to adapt with commercial movement from physical marketplace to online and virtual one. So you can see that now only trademark infringement and especially in retail business, they're really moving from block and barter marketplaces into online virtual marketplace now. So e-commerce platforms actually it targets now for brand owners to look into. Vietnam, we try to amend the IP law now in order to comply with the new EVFTA and CPTPP. Hopefully in November this year, the amendment will be effective. Under the amended law, the trademark use of authorized licensee can also be considered as use of trademark owners. So you mean that if you license the trademark to a local Vietnamese licensee, and then that will be sufficient evidence to confirm, to prove that the use of the mark is proper. And also under the current framework in Vietnam now, Customs Agency have authority to apply border measures on imported and transit shipment. That's quite interesting as well. Border measures, including customs recorder, customs restraint, and customs suspension, have recently been available in Indonesia since 2018. It's quite good news. However, customs recorder application can only be submitted by Indonesian business entities. So foreign right holders must request recorder application through their local subsidiaries. It means non-Indonesian based entity cannot do it. So now the next slide, I will talk a bit about ASEAN cooperation in IP enforcement. And then we have about a few minutes to talk about Q&A. Okay, so ASEAN Framework Agreement on IP Cooperation 1995. This one, the ASEAN members countries agree to undertake cooperative activities, which shall include, inter alia, activities to enhance IP enforcement and protection. So such activity will include effective protection and enforcement of the IP right, cross-border measures, cooperation, networking of judicial authorities, and IP enforcement agency. We also have an AEC blueprint. It means ASEAN Economic Community Blueprint. So that emphasizes the principle that IP can influence both the volume and quality of external trade and investment, and transfer of advanced and technology, as well as being a major determinant of the local value added and external competitiveness. Last but not least, we talk about ASEAN IP Enforcement Action Plan, and this one
will have to foster the exchange of information and best practice among ASEAN members. So in terms of ASEAN cooperation in IP enforcement, I think that in ASEAN, they are trying to take a holistic approach where the context of principles are embodied in the agreement adopted by ASEAN, and so the following approach will be applied in fourfold. Number one, from the point of view of the consumers, in order to raise awareness. Number two, from the viewpoint of the IP owners, that will have to establish a collaborative mechanism with public official and agency. Next on, from the viewpoint of the public authorities, that will have to strengthen to the capacity of the official and government dealing with IPR. Last but not least, from the viewpoint of ASEAN as a region, we will try to establish an institutional mechanisms and linkage for collaboration and information exchange among public authorities in ASEAN countries. So we have only almost 1 hour to walk through the AEC framework, the IP prosecution. IP prosecution means IP establishment, right? Establish your IP rights, the trademark rights in ASEAN. And the last one is the IP enforcement in ASEAN. And I also received a number of questions from you here, 3 very interesting questions. But before I answer these 3 questions, I'm asking whether you have any question for me. You can type it, text to me, or Nora, or to Chan, or you can speak it out. So Q&A session start from now. Good morning, Europe.
Everyone, for the technical difficulty in the beginning. I hope that after it was solved and you could enjoy the presentation. It was really insightful. There is one question I wanted to. I've received. Yes.
Yes.
Can you hear me?
I can hear you. Yes.
Mr. Hung, can you hear?
Yes, I can hear you.
Hung, can you hear?
I can hear you. Yes, I can hear you.
Yes, you can hear me.
Yeah,
okay,
I
didn't hear from you. So there is one question about the trademark registration. Yeah, so if a company wants to register the trademark in Vietnam, is it necessary to?
Yes. Can you hear me now? Vietnam is the first to file country, and before doing business in Vietnam, or even before you plan to do business in Vietnam, it's important to file a trademark in Vietnam, because we are the first to file country. It means if you don't file it, but a third party file it, and you are losing your right.
Yeah. Okay, thank you, Hung, for the reply. Can you hear me now?
I can hear you. Yes.
Okay, great, because I think you didn't hear me before. So there is another question. If a company wants to register a trademark in Vietnam, is it important to make a translation to the local language as well?
In Vietnam, we accept the English and Latin-based language. It doesn't need to be in local language.
Mm-hmm. Okay. And what was? Yeah. And another question would be that. So you recommend that English is enough and not necessarily a translation to Vietnamese.
Right. However, okay. From time to time, we have big clients, and they have concern about local companies trying to replicate or trying to copy their trademark in the local ways. So they normally do a defensive filing by filing some core major Vietnamese, trademark.
Okay. Okay. Thank you for your reply. I don't see more questions here from the audience. Is there any further question you wanted to share, Mr. Hung?
Yeah. So Nora, I received 3 important questions here, and I can answer to the audience if you don't mind. We still have about 10 minutes,
Yeah,
5
sure.
minutes, right?
Yeah,
Okay.
correct.
So question number 1 is, I have a trademark registered in EU. Is my trademark protected in ASEAN? Okay. So my answer is trademark registration has territorial effect. It means if you file in EU, you cannot get protection in ASEAN countries. So you have a number of options to get protection in ASEAN countries. Number 1, you can file that trademark in each ASEAN countries. We call national filing. Or you can use the Madrid Protocol to file the trademark. So you get protection from those 2 options. Yeah. And of course, if your mark is a well-known trademark in Europe and around the world, and you will get, trademark protection automatically in ASEAN. However, it's not quite easy to get recognition of the well-known trademark. You have to prove a lot of evidence. You have to come up with a lot of evidence, and sometimes you have to go through, legal proceeding in order to get recognized as a well-known trademark. Okay, that's question number 1.
Mr. Hung, thank you for the reply. Sorry, but in the meantime, another question came in from the audience, an interesting question, so I would like to share with you. Do you expect Vietnam to create an IP court with the upcoming revised law? If so, will this provide easier access for litigation?
That's a very good question. In Vietnam, we talked about having an IP court for many, many years. And right now, even my colleague and we are still pushing for having an IP court. And I believe that in future, we will have one.
Okay, thank you.
Okay, the next question I received is, what is the best way to stop infringement of my trademark in ASEAN? So this is quite a broad question, but I can tell you some advice here. Number 1, to determine how to stop the trademark infringement of your trademark in ASEAN, you have to consider some factors. Number 1, what kind of infringement it is. So depending on the amount, volume, and also the sort of infringement, you can decide whether you should take an action, civil action or administrative action. And also depend on the seriousness of infringement. If your trademark is in pharmaceutical, cosmetics, and of course, criminal action sometimes is quite important to consider, but it's in fashion stuff, retail, and a very easy way, very cost-effective way is to send out a warning letter, cease letter. That can save a lot of money, and then you can negotiate with the infringer, they can stop it. And of course, you can use the cross-border measures to record your trademark with custom officers, and then you can detect from the incoming, outgoing possible trademark infringement counterfeitings. And the last question I received from you is, what are the current issues affecting trademark protection in ASEAN? Okay, this is the challenge. Each country in ASEAN has its own mechanism and practice for trademark filing and protection. So it's quite complicated for foreign applicants from Europe who wish to establish right in multiple countries. Okay, that's the first challenge. The second challenge is legal framework for trademark in some ASEAN countries like Laos, Myanmar, Cambodia are quite new. So local authorities, when we have been working with, we found out they are very incompetent and they don't have a lot of experience in applying the law. And of course, corruption is important. It's quite a big issue in their country as well. So that's why enforcement is a little bit troublesome. The next challenge is online infringement is becoming a major part in ASEAN countries. While some countries do not have sufficient technological facilities to detect it, and some countries were advanced like Singapore. So we think online infringement is quite a big challenge. And this is a trend in ASEAN. So ASEAN countries are constantly improving the legal framework to build better mechanism to protect trademark, as I show in my presentation. And the trend here is many ASEAN countries have entered into new FTA, like Vietnam, we just entered the EVFTA with Europe, and that will will become a quite big thing for Vietnam to protect IP rights from Europe and likewise from Vietnam to Europe. And next on is that ASEAN is quite actively working on cooperative and uniform system for trademark prosecution and enforcement from the IP action that I mentioned in my presentation. So those are the 3 questions that I received from the audience. So feel free to ask the question now. If you don't have time, you can send your question to my colleague Nora, and she will kindly pass on to me, and I will answer right away. So Nora, back to you.
Yeah, great. Thank you very much. Yeah, thank you very much, Mr. Hung. It was very good, the additional clarifications. And I think we arrived to the end of this webinar. So just to wrap it up, you are very welcome to follow us on social media through our website to be updated about our upcoming activities and see the next webinars that we organize in the upcoming months. And if you have any questions related to this specific session, please feel free to contact us. And also, if any further IP doubt comes up, also you can email to us and we will be very happy to reply to you. Once again, thank you very much for your participation. Thank you to Mr. Hung for this very interesting presentation, and have a nice evening or afternoon to all of you. Thank you. Goodbye.
Thank you. Goodbye, and have a good weekend, everyone. Bye-bye.
Good weekend. Bye.